It is for 3 words.
Well,
Here you go.
I didn't know that should be. It's very sweet. All right, it's 5:02, December 18th, 2024. Let's call our meeting to order.
Jeff Going,
Here.
Don Sadler,
Here.
I'm here, Carrie Miller. Oh, wait. Oh, sure. I didn't see it.
What's your name?
Yeah.
Aaron.
Please take notice that Don Sattler, village president, chairman, Gary Annenberg, village clerk, Jeff Goins, trustee, constituted municipal officers, electoral board of the village of Poplar Grove for challenges to nomination papers for offices of the village president and village trustee for your term will hold a meeting of municipal officers like the board for hearing and consideration of objections, petitions to be voted upon by electors of said village at the consolidated election to be held on April 1st, 2025. We'll hold a meeting of municipal officers like the board tonight, Wednesday, December 18th. We commenced for the purpose of hearing said objections to petitions. I have a comment here, or introduction, and I'd like to say good evening, everybody. Thanks for attending. This is the hearing of the Village of Poplar Grove Municipal Officers Electoral Board, set for Wednesday, December 18th, 2024 at 5 p.m. Time now is 3. And Don Sale, the chair of this electoral board, I'd like to call the municipal officers electoral board meeting to order. We already called the roll of members. Presence. I'm present. Karen Miller is present. Jeff Cohen is present. The majority of the electoral board is present. We place a few items in the records. The open meeting act notice. Today's hearing will be Board Exhibit 10. The transcript of December 4th, 2024 meeting will be Board Exhibit 11. We will now begin the call of docket. The first case is Allgood versus Earp, case number 25EB01. And I will turn this over to the attorney for handling.
Hey, do we have anyone here on behalf of the objector?
David Wiltsey, on behalf of the objector, WILTSE.
Anyone here on behalf of the candidate?
Yes, Robert Winden, Windon.
All right, so when we were here on December, is it on?
Sure.
Red one.
Red one, it's got to push down.
It's on.
Okay. It's on that one?
Yep, if you just, it's on the chat.
Okay, so on December 4th, when we were here, we established some deadlines for motions. Mr. Winden was going to file a motion by December 10th. Mr. Wiltsey was going to file a response for December 16th, and then Mr. Winden was going to file a reply by today. Now, on December 10th, we received a motion to strike and dismiss filed by the candidate. On December 16th, or actually on the 17th, we received a reply from Mr. Wiltsey, and then there was nothing filed.
Correct, I did not find anything filed, any reply to this. I will just argue that orally today. I think all my arguments.
Okay, and then today, we also did receive an email from Mr. Wiltsey that we copied Mr. Winden on, stating that after consulting with his client, they concluded it was not best to go to court to try to work on anything related to the composition of the board. They're preserving their arguments. So I think we should put that into the board exhibit as exhibit number 12. So is there a motion of the board to put the Open Meetings Act notice, the transcript, and this email into the board's exhibits as exhibits 10, 11, and 12?
I'll make that motion.
Is there a second?
Second.
All in favor, aye.
Aye.
Opposed? Motion carries. All right, so the first preliminary matter that we have then would be hearing on the motion to strike and dismiss. And because the candidate has made the motion, Mr. Whitten would go first.
Thank you very much. So, my motion is very, I guess, can be very simple in the sense that all I'm arguing, and I know there was a little bit of the reply from counsel on that he filed it, it was filed properly and whatever else, and it was. The objection met the form of the objection. Sometimes we have these motions that the objection, isn't proper, wasn't timely filed, things like that. All of that in this case was proper. Even with all the pleadings being admitted as true for the purpose of this argument, their objection does not rise to the level of something that should strike, should demand my client's name be removed from the ballot. To highlight what is already in the written motion, the Illinois courts have long laid out with the proposition, along held the proposition that the default of electoral boards is to allow ballot access. That we should be looking for, and I will quote it, wherever reasonably possible, election statutes should be construed in favor of ballot access, not denied. And any reviewing body should, quote, tread cautiously, unquote, when interpreting statutory language that restricts the people's right to endorse and nominate the candidate of their choice. The citation. And I need to make sure that, put that out there. That's where the board should start, is that we assume we are going to leave candidates on the ballot before we move forward. And then, obviously, there are times that candidates don't meet the standards of the law, and they are stricken and improperly so. It is my position that essentially the objector's petition, while were numerous paragraphs, and that's again appropriate, that there are basically two issues, two complaints, two things that the objector stated, and those are the reasons that they believe my client should be struck from the board, her name should not be printed on the ballot.
Can you read two reasons?
Yes. So the reason number one is that the candidate used the wrong form, did not use the form listed in the Illinois State Board of Elections candidate guide. And I think it is important for this board to note the candidate guide is just a guide. It is not law. There is nothing that says you have to use their forms. In fact, if you use their forms and whoever put it together that year didn't catch a change in the legislation, the fact that you relied on that form does not mean that your petition is valid. It's to give candidates, some level of a guide or a basis. So in my opinion, my argument is anything in the objection that just says my client's name should be struck because she didn't use that form is incomplete as a matter of law and is irrelevant, should be ignored by the board. The rest of it has to do with what was in the statement of candidacy, what information was there. Those are the rest of the paragraphs stating that what was in the statement of candidacy was not appropriate for a municipal election, and that based upon that, and this is my second issue that they raised, is that voters were confused, or voters could be confused. It's important to note that a couple things when we get to that. One, voter confusion is only an issue that the Illinois courts have looked at when we are considering things that the voters themselves saw. So generally, the pages they sign. If the page that a voter signs says somebody is running for alderman, and that town happens to have 8 aldermanic districts and they're all up for election, well, that person didn't know for, and so the voter could be confused.
So, let me interrupt. So, you're saying that we should look for the wrong, what the checker said, but it's also the person who's running's responsibility to make sure that they read the properly, so that there is no issue. And that they also fill the correct forms, so that there is no issue with any voter misunderstanding or confusion.
It is the candidate's responsibility to make sure to file the proper paperwork. Yes. What I'm saying as to the voter confusion is that is an issue that should not be addressed by this board, because the complaints, the objection lays out issues with my client's statement of candidacy. And Illinois courts have gone through and stated that voter confusion is only relevant when we are talking about something the voter sees, being the signature pages. Because the voter doesn't see the statement of candidacy, we don't worry about voter confusion. The issue is statement of candidacy, and I'm not saying an improper statement of candidacy can never have somebody missing something on there, can never have somebody struck from a ballot. That's not the law. But Illinois courts, when they're worrying about the packet as a whole, or they're worrying about the statement of candidacy, the standard that is used by Illinois courts is substantial compliance. Did they substantially comply with the law? And essentially, the purpose of a statement of candidacy is to put the village, the county, whatever clerk on notice as to what office that person is seeking. I have gone through, and I don't want to restate the entire motion, but Illinois courts have consistently held that as long as the statement of candidacy is substantially compliant with the law, the candidate should not be removed from the ballot. And then there's a couple cases that I cited. One, an improper notary, another one which is very applicable to here, Zurich v. Cook County Officers Electoral Board, 2014, ILAP 1st 140446, where stating that using the wrong form that failed to state the candidate was, quote, a qualified primary voter of the Democratic Party, unquote. That was the language that the law asks to be put in, that was flat out omitted from the statement of candidacy. The court held that was substantial compliance. That met the burden, and that candidate should remain on the ballot for the office sought. So, the other thing that the courts have looked to, that I think is relevant, is they don't just look at the one piece of paper. If the statement of candidacy has a minor issue, the clerk and then the electoral board and the courts are charged with the idea to look at all of the nominating papers as a whole and say, hey, do we know what office this person is running for? And it is my argument that we look at this full nominating packet as a whole, and it is clear that the office that my client was running for, where she wanted to run, all of that information was clear, it was straightforward, and just because there were some technical defects on the statement of candidacy, she still substantially complied with the law, and she should remain on the ballot.
What's your definition of technical statements
My definition,
on her statement of candidacy?
Can I clarify that question? I think the question is what, according to electoral code 10 ILCS 510-5, what are the required statements in the candidacy? I think there's 6 requirements according to the code. And number 1 is it shall set out the addresses of the candidate. Number 2, the office for which he or she is a candidate. Number 3, shall state that the candidate is qualified for the specific position. Number 4, has filed or will file before the close of petition filing period, and a statement of economic interest as required by the Illinois Government Ethics Act is filed. Number 5, shall request that the candidate's name be placed upon the official ballot. And number 6, shall be subscribe to and sworn by such candidate before some officer authorized to take acknowledgement of the deeds of the state. Have those 6 things been required on them?
So my position is they have, and the technical defects, it's something you were asking for an example or something that I think may have been.
I
Yeah.
didn't know I was gonna be interrupted by Mr. Sadler, so sorry.
I think Mr. Chairman properly stated the law, and I appreciate that. And to the technical defect, you know, I don't think the objections as they laid out are wrong from a factual basis. That the statement of candidacy mentions a nomination by caucus. That is not the way that this village puts people on the ballot. They do so by the signatures gathered throughout the community. So that is a technical defect in the statement of candidacy. But when I believe just looking at the statement of candidacy itself, it's clear what the candidate was asking for. And then more importantly, once the statement of candidacy and all of the nominating papers are read as a packet and looked at as a whole, it is clear that the candidate substantially complied with the law and substantially complied with the elements that are necessary for the statement of candidacy. So for all those reasons, I believe, even with all the facts as presented in the objection, as a matter of law, they don't rise to the level that not only require, but even would allow this board to remove my client from the ballot. That's that this board grant the motion to strike and dismiss the petition in its entirety, or the objection, excuse me, in its entirety.
Mr. Lutzy?
Thank you. In this case, it is an unusual case to be sure, but in this case, the statute that sets up nominations and elections for municipal governments, for nonpartisan municipal governments, is 10 ILCS 5/10-3.1, which talks about petitions for nomination of nonpartisan candidates for office. And the statement of candidacy is a partisan statement of candidacy. And it's not just that it's the wrong form. It makes an indication that the candidate was duly nominated by said party, in this case the Republican Party, at the caucus. Well, there was no caucus. And there is no, or should it not be, any Republican candidate for village president of this village, because it doesn't work that way. This isn't Berwyn, this isn't Belvedere, this isn't Cicero, where there are some towns, Chicago, where there are people that are on the ballot as Republicans and Democrats and so forth. And in this particular case, and I know that you have, we've admitted these as the packet, but I think it behooves us to look closely at the statement of candidacy. If I may approach, this is an unmarked copy, just as it is in the file, and leave it with counsel and my opposing counsel. Now, while I agree that the candidate guide and the local official guide, as a matter of fact, is in fact a guide, not the law, not a rule, they had these things put together so that people grab the right forms and use the right forms. And as I say in my objection, and as we say in the reply, this form is for township government. And it says right in the manual, the guide, this is for township government. Now let's look at this closely. Under the word statements of candidacy, it says nomination by caucus. Didn't happen. For party, it says independent. There is no independent party in Illinois. There are millions of people that are independents in Illinois, but there's no independent party in Illinois. The district is Poplar Grove, and of course, Poplar Grove is the municipal entity, not a district. Let's look at this now. Going down about 5 lines after candidate gives her name and her address, and that I am a qualified voter therein and a qualified primary voter of the Republican Party, and that I am a candidate for the office of village president of the village of Poplar Grove. Notice there you've got this little, in parentheses, a city, village, or township that isn't even circled. It's circled village. As duly nominated at said party's caucus. Didn't happen. And that's covered not only in what my client has averred, but in the secretary of the Boone County Republican Central Committee's affidavit, which is attached to the objection. Jonathan Gieske, the secretary of the Boone County Republican Central Committee. And is, by the way, as I say, it is in the statute, where the stat is established by the statute, the Boone County Republican Central Committee. He says, we don't do it this way, never happened. We don't slate candidates for office in Boone County for municipal office by party. And then, so if you go further, it says after the nominated and said party's caucus, which didn't happen, and she says, I seek the nomination to hold such office. That's what usually happens in primaries. And that she wants to be a name printed on the official ballot for the election to such office. Now, this is not just a statement. This is a sworn, notarized statement. And it has 2 major errors. There's no village president candidate that's a Republican, and there was no caucus. And that's what the problem is here. It's not just that it's the wrong form, it's that the candidate is holding herself out as the Republican candidate for village president. Now, Boone County, as I say in my objection, and it is stated in Mr. Gieske's affidavit as the secretary of the Boone County Republican Central Committee, there isn't a single office holder county-wide in this county that's not a Republican. And I'm not talking about state reps or state senators. I'm talking about county officers. There are no Democrats on the board. There are no Democrats on the county board. There are no Democrats in the offices. And in fact, in this last election, you might have noticed if you took a ballot, there were some offices that were unopposed, and the Republican candidate ran by themselves. Now, we have just come out of one of the most contentious and contended campaigns in the history of this country. And the voter confusion that the Republican Central Committee is worried about, and others of us that are involved in politics, is that this holding oneself out as the Republican candidate for village president could cause great confusion, particularly when some of the Belvedere Township presidents are actually in this municipality of Poplar Grove, and people down in there, not in 16, of course, they don't get on the ballot that way in Boone County 16. They're well aware that there are candidates that run for as Republican and Democrats in the village of Belvedere. So when we talk about substantial compliance here, substantial compliance, generally speaking, is a judicial created doctrine where they can look over all of the documents and determine there's a substantial compliance. And that comes after a hearing on the merits. We have not had a hearing on the merits, obviously. We have a verified statement under 1109 of the Civil Practice Act, which, by the way, is, I guess, about 25 years old or so. And it is a verification that attorneys, I've got in my hand the objection, the verified objection, my client, Mr. Allgood. This 1109 verification was put in by the Supreme Court so that counsel or the clients could verify their complaint without having to go chasing around for a notary or anything like that. So a 1109 certification, verification is what, when I keep saying it's a verified statement in all these various paragraphs, that means that Mr. Allgood has verified that by this 1109 process. And if you look at the last page of the objection, there is the affidavit of the Secretary of the Boone County Republican Central Committee. That's sworn and notarized. It's sworn and notarized, I believe, in accordance with the Supreme Court Rule 191, which even avers at the bottom, if called to testify, I would testify affirmatively and competently to the facts as stated herein. And again, the Secretary of the Republican Party for this county goes over some of these defects in this petition and says flat out that he believes that this is going to be causing voter confusion and is misleading and should not stand. So the difference in this case is if we strike the statement of candidacy, it misses a valid, required, and mandatory document, and therefore the candidacy fails. In my reply, I set forth the elements of paragraph 10-8 of the Illinois Code of Civil Procedure, which deals with the issue of objections. And it's a long section of the statute, but this is the key wording, and I'll read it. It's one sentence. The objector's petition shall give the objector's name and residence address, and shall state fully the nature of the objections to the certificate of nomination or nomination papers or petitions in question, and shall state the interest of the objector, and shall state what relief is requested of the Electoral Board. That's all the statute requires. And I want to point out there's a line at the end of my reply in which I say, and I say it to you now, this was a statutorily created method by which voters could become objectors to bring their case before an electoral board. And that's exactly what we're doing. And we have a verified motion, and we have an affidavit in support of it, and there's nothing in the record from the candidate other than argument that that's not sufficient enough on its face. And I believe that this electoral board owes the statutory duty to my client to allow us to have a hearing on the merits. Now, my belief is in what's going to carry this thing. We're going to look at what the Supreme Court said and how you judge a Rule 2615 motion to strike. In the case that was used and that I have cited, and there are many cases like this, this concept of the law hasn't changed in decades. When you have a motion to dismiss like this, all of the facts well pled are presumed for the purpose of whether or not this motion will be granted, are presumed to be true and liberally construed in the favor of the plaintiff, which in this case is the objector. And that the case I cite is the Marshall case. In that case is a real tragedy. As you may know from reading this, I mean, Mr. Marshall's son was in Burger King eating, and a car crashed into the restaurant so hard it carried itself through into the restaurant lobby area, the dining area, and hit him and killed him. And, the trial court said that this wasn't, public policy, there was no duty here. And this set all sorts of things in motion that the trial justice didn't think would be appropriate. And so we granted the motion to strike. The Illinois Appellate Court reversed by a 2-1 vote, and then went to the Illinois Supreme Court. And this is the language of the Marshall versus Burger King court case, 222 Illinois 2nd, page 422, and also page 429, a 2006 case. In ruling on it, and this is how I'm reading from now from page 3 of my reply. In ruling on a section 2615 motion, the court will accept as true all well-pled allegations, liberally construe those allegations, and draw all reasonable inferences in the plaintiff's favor. Liberally construe those allegations and draw all reasonable inferences in the plaintiff's favor. As a result of that standard, the Supreme Court reversed and sent it back down to the trial court for further proceedings. Now we've got 16 paragraphs in the objection that are detailed, and they're verified. And on one of them, one thing that the 1109 verification allows you to do is say something on your information and belief. Mr. Allgood believes that this will have an impact in the campaign. What has happened in this statement of candidacy in this alleged nomination at said caucus. And on his information and belief, he has signed that 109 verification. And I submit to you, we can't be in a position here where we say that the argument of counsel and his response is good enough to do this. The question of whether or not this is a valid objection is one that ought to be heard on the merits with testimony. How did this happen? How did this candidate sign a notarized statement that said she was then nominated at a caucus? This is really, I think I told you last time, the first case I had out of law school was an election case since 1981. I've never seen anything like this. And I do know that people draw inferences in politics. And if this candidate is going to hold herself out as a Republican candidate, and her paperwork says that, I have to believe that that's what's going to happen, and that is problematic. That's why we need to go to the evidence. That's why we need to find out what's really going on here.
May I ask a question?
Sure.
You strayed way off the electoral code here. It's clearly under section 10.5 of the election code. You've gone way off on different tangents. So 6 questions that the other attorney that answered that is pertinent to the specific law that governs petitions and electoral code. All this other stuff doesn't. And question 1, shall, the election code provides that the required statement of candidacy shall, and it uses the term shall set out the address of such candidate is on it. Is the candidate's address on there? Number 2, the office for which he or she is filing for candidate. Is that on there? 3, shall state that the candidate is qualified for the office specified. It's a statement of candidacy. It's a request to be on the ballot. 4, it has been filed or will be filed before the close of petition filing, and a statement of economic interest as required by the Illinois government ethics has been provided. Has that been provided, Mr. Wilson? 5, shall request that the candidate's name be placed upon the official ballot. Has that been requested? I believe that and the other forms is a request to be placed on the ballot. And number 6, according to law, shall be subscribed to and sworn by such candidate before some officer authorized to be acknowledged. That means has it been notary? Has that been taken care of? These are the 6 tests that the electoral court requires. All the other stuff is just, you're talking about criminal law and civil law and all types of other filing procedures, and that's all well and good for your opinion, but you haven't answered these 6 questions that are requirements specifically under law, and that's the only law we need to look at.
First place, I'm under 10.8 because that's the objection section. Second place, there's nothing, we're not talking any criminal here, I didn't argue anything like that. Third, the qualification language that is in this statement of candidacy is qualifications for township assessors and multi-township assessors. So I believe that that's defective.
Let's focus.
If I may answer now.
Number 1, let's focus on the law here, okay? Number 1, just focus on the law. Don't.
I'm trying to get my turn to answer your question.
But you're not answering the 6 questions.
I'm getting to it.
Okay.
I answered number 3, and now I'm going to answer number 6.
Okay.
There is no good swearing in this case. The swearing was fatally defective. And number 6 fails as a consequence. It's not just a rubber stamp on a document. It's a swearing under oath that the contents of that document are correct. And the contents of that document are not fully correct.
That's not what it is. Number 6, you said, right?
Number 6.
You're answering number
Sworn
6.
Sworn to.
Shall be subscribed and sworn to by such candidate. And it is.
It is, but it's falsely,
It is. You answered the
it's
question.
falsely
It is.
subscribed to. And that's the point, that's
No,
why
it's
we,
not.
ladies and gentlemen of
No,
this
it's not.
panel, this tribunal, that is the point why we have to
Number
have a
one.
hearing on the merits.
Number one. Did you answer number one?
I only need to knock out 6, Mr. Chairman, in my opinion.
That's your opinion, that's not the law. The
Right.
law has 6 tests right here, you're not answering.
He doesn't get test number 6, and that's failed.
You're not answering, you
That's
ignored
fake.
5 of them, so.
And I didn't ignore number 3. Now, if you let me.
You didn't answer number 3.
May I have the floor and finish my statement?
I'm asking you to simply answer the question.
I did.
of the law.
Number 3 is the qualifications for township assessor, not the qualifications for a municipal
Shall
office.
state.
And number 6 was not properly sworn.
Can you let him finish?
Number 6 wasn't properly sworn,
Very
period.
good.
That's my answer. So, let's see.
Let it be known that he doesn't want to answer the questions.
Mr. Chairman, if you're going to speak facts, speak facts.
I just did.
Good.
I
That's
just
what I
did.
said.
You haven't answered the question, you answered.
3 and 6 are defective.
You-
Okay,
you're
and
not
all
answering
6
the
have,
question.
all 6 have to be done. So, in conclusion, we have set out a verified claim of problems here. We have set out an affidavit also setting out problems here. There is nothing in this record under oath by this candidate that can stand against that at this time. And according to the standards set in the Marshall versus Burger King case, you should deny the motion to strike and we should proceed to set this matter for hearing on the merits. Thank you.
I guess my confusion here is I don't understand what council wants. Purpose of this motion, I stated for this motion, we're accepting all their facts, not for the hearing. If not, if we get you one, we're not conceding anything. But where council and I do agree is the standard for a motion to dismiss is that the board, the court, whoever is hearing it, has to accept the well-planned facts, yes, liberally construed, yes. Where appropriate, you give the deference to the plaintiff. We're not, for this argument here, I'm not saying anything they're alleged in the objection is a lie. I'm not saying anything is inaccurately stated. What I'm saying is I don't care. None of the things that they have said give rise to knocking my client off the ballot. Again, I read the motion I filed, but the courts have consistently held that a statement of candidacy and the signature pages on a petition are analyzed differently because the voter never sees a statement of candidacy. So we can't argue, we can't worry about where the voter's confused with a statement of candidacy. They never see it. What the question for this board is taking all of the objector's facts as true. Does the statement of candidacy substantially comply with the law? Does it say what the candidate wants? She wants to run for village president. Say where she lives, what village she wants to run for president in. And then she's swearing to that. It lays it out in the 4 corners of the document. Yes, there are some extra things in there that are technical violations. The Illinois courts have consistently allowed violations or for missing parts of a statement of candidacy. The Seminole case dealing with substantial compliance in Illinois election laws, Lewis v. Dunn, 63, Illinois 2nd, 48, and Lewis involves a violation of the statement of candidacy where the Illinois Supreme Court held that literally the failure to specify the vacancy, to not say what office the candidate wanted to run for, did not mean the candidate wasn't to be put on the ballot. Because the board, the courts could look at the entire packet together. Oh shoot, the candidate forgot it here. Literally what would seem to be the most obvious thing that you cannot forget, besides maybe your name, is what office you want to run for. And if you can literally leave that off, and then just expect the board and the clerk and whoever else, you then look at the rest of it and go, oh, on the signature page, as she stated that she's running for village president, okay, that's what we're doing. If my client had stated on the signature pages that she was nominated or appointed to this position via caucus of the Republican Party, that would be a problem. But because it's on the statement of candidacy, it's not. This is all just a red herring. This is all just for us to all be here and to set this matter over for a hearing on the merits so we can hear testimony to all the things that are already sworn to that, for the purpose of this motion, have been admitted as fact, would just be a waste of everybody's time. We can rule on this objection while, for today's purposes, assuming every single thing the objector said is a fact, without sitting here for 2 hours, listening to the objector and any other witnesses they want to call, say the same thing over again. Because even with that all being a fact, my client substantially complied with the law as it has been laid out by Illinois courts. So I ask again, that you grant the motion to dismiss and strike the objection in order that my client's name be placed on the consolidated election ballot. Thank you.
Okay, so the board needs to make a decision on the motion to dismiss. And basically, a motion to dismiss does presume that all of the allegations are in the objector's petition are true. And so what the candidate is arguing is that even if everything's true, the candidate would still stay on the ballot because the objector's petition doesn't sufficiently set forth a violation of the election code. Now, what the objector is saying is that, well, when you look in the election code as to what an objector's petition has to state, it has to list those things that Mr. Wiltsey said. It has to have a name and address, it has to fully state the nature of the objections and state the interest of the objector and the relief required. So the objector is saying this has all the ingredients that it needs to have in order to go to trial. And I believe that the objector is also saying that the fact that the candidate's statement of candidacy has a statement in there that's sworn to under oath that candidate was nominated at a Republican caucus. And because that's a false statement, that makes this entire statement subject and invalid because there's one statement in it that's not true. So what the board needs to decide is, do you believe that it doesn't state enough of a violation of the election code because there's not, this is saying that the wrong form was used and there's not really a law that requires anyone to use a form as long as you set forth the 6 elements that the village president has read forth from the statute. And the second allegation here is that there was voter confusion.
My statement of candidacy was with my petitions, what I presented them to the public for their signatures. I don't understand why she would present it with it. If I see that there's a caucus, I would be caucus. So to me, she basically lied. If people did read this statement, if people read this when they went to sign the things, that was a blatant lie to those people whom I would encourage them to sign, saying she was a Republican and there was a caucus held. You see my point?
So
To me, that would be confusing to me, and she firmly notoriously lied.
So it sounds like what we're saying, if I translate it back into legal terms, is that if we take the objector's petition as true, paragraph 15 of the objector's petition says the statement of candidacy is false, misleading, and likely to cause voter confusion. So in your opinion,
And then I found out that she didn't have a caucus. It was not true. When it was president, it was true.
so then what you would do is you would make a motion to deny the motion to dismiss, so that there would be a hearing on it all?
You know, I would have been confused. So I would have to agree, I have to make a motion tonight.
Okay.
Were you supporting on 1 of 3?
So this is, all right, so if you make a motion to deny the motion to dismiss, what that would mean is that the case would now just proceed to an evidentiary hearing. If we dispose of the case, we would go to the next part. So there's a motion to deny the motion to dismiss. Is there a second to that? It is a very confusing
It is
process.
confusing, but I'm just saying, me as someone who comes and knocks on my door, like I said, when I ran, I had my statement, it was their candidacy, they read through it, they asked me what I'm running for, and then I was challenged on my things as well, of not being properly filled out, but mine was the proper paperwork, mine was the proper thing, I signed a thing, everything on there was true to my knowledge, but I didn't say I was in a caucus, or, you know, I'm not a Republican, I'm independent, you gotta run independent for this position. You know? So I could see the voter confusion.
Is that true? You can't have a partisan position?
Well, Poplar operates under a nonpartisan election system, so people can't, well, you don't.
You don't say you're a Republican or a Democrat. You keep that to yourself. It's your choice to do what you want, but we're not partisan, so we don't put this on our statements.
No, really. If we decided, when we looked at this before, is it nonpartisan or partisan? Remember? So people didn't file for the primary, and you haven't adopted the nonpartisan runoff system.
Yeah, we do not have a primary.
So I think it's a partisan form
Partisan.
of government, because in that case, that's how, you can only run as an independent candidate when you have partisan elections, because if you're running as independent, that's designating that you're not running affiliated with the
Party.
I
Right.
think the confusion with the county clerk has always said that you're not partisan.
Because sometimes people confuse the terms nonpartisan.
Yeah. We have letters from them saying, you know, oh, Bakeridge, Poplar is not partisan, so these are your stuff. So I think that's what, I think also because we haven't had a Republican, Democrat, or a party run here. I have stuff back there since 1990. So, everyone's always. I think that's where.
But it's not lawful.
Right, that's correct. Because you can't run as an independent candidate in a nonpartisan form vote.
I have to correct you,
So that would make that false.
Actually, counsel, I have to correct the record on that. I
We're
read you from,
in deliberations at this point, unless we're gonna.
yeah, this is an incorrect statement of the law. and I read
That's
you-
okay, that's, if they're gonna reopen it up for discussion, that's fine, I think we're in deliberations.
I would like to address the board again.
Sustained. Readdress the parties again?
We can.
Okay, first place, the Lewis case is a case where they went to a hearing on the merits. And the Lewis case was under Article 7, not on Article 10. Article 7 is the partisan Republican Democrat thing. Now, what I read you before out of 10.3.1, talking about nonpartisan nominations, in 10.3 though, it says independent candidates, and it refers, this statute refers to 10.3. Because as you may recall 2 years ago, when the county clerk was testifying, if you were in the panel, I do not recall, there weren't any independent forms under the nonpartisan thing, and so people used the independent form because that's the only form the state board had for municipal elections that aren't under a partisan setup. So that was what I was trying to get to. It's not a partisan form of government. It's a nonpartisan form of government. It's specifically under state statute 10.5, 3.0, independent forms can be used or a nonpartisan form can be used, but one exists. but the two flow into each other, and the nonpartisan one has nothing to do with Republicans and Democrats. That's the first, that's that, and that's Lewis and Lewis, they had a hearing on the merits, and that's what we're trying to get to here.
So they are a partisan. They have not adopted the nonpartisan runoff form of government. We checked with Boone County. They've never adopted that. And you cannot run as an independent candidate in a nonpartisan form because independent distinguishes you from being partisan. So we've researched that previously. I don't think that actually has a bearing on this case though. But Mr. Winter.
That's what I wanted to point out, so council just stated, I agree, this is just because people run without a party affiliation, this is, Poplar Grove has not adopted the quote nonpartisan form, and I also agree, it's irrelevant, it's a semantic thing, even if it had, but I don't want to get into that law because it's not relevant today.
So we were in the middle of addressing the clerk's questions.
So. Motion, we need to do a motion to do that.
There's a motion to dismiss
I,
the objector's petition, which would say that everything would just be over because even if everything the objector is saying is true, it's not legally sufficient. So then the case would be over because we dismissed the objector's petition. So he's made a motion to deny
but
the motion to dismiss.
I think it's voter confusion.
I can make a motion to dismiss.
I make a motion to deny because if it was me, like I said, my statement was with my signatures. I didn't have anyone getting me signatures. I went out and got my signatures myself. So my candidacy statement was with my signatures. And that was the first page that was on my clipboard. Explained to them off of my candidacy statement what I was writing for. And if they had any questions, I would ask them. I told them I was here living in the village. This was my third term. I didn't lie, I signed an affidavit, or thing was notarized, and I told the truth. I didn't have no caucus. So to me, it's voter confusion, in my opinion. So I would make to deny it.
Motion to dismiss it for the reasons under the law and the election code itself. Section 10.5 of the election code and the 6 tests for substantial compliance.
You,
That's what the law says. It's not feelings or beliefs.
different.
It's actually the law. And the law is what matters.
Give the highest elected official.
Okay, so Madam Clerk, there's,
Two motions, so I
Yes,
need
there's
to second one of them?
yes, there's a motion to deny, the motion to dismiss, and there's a motion to grant the motion to dismiss.
I'm gonna second Jeff's motion.
Okay, so there's a motion and a second to deny the motion to dismiss. Is there any further discussion on that?
So that means how many, we end up having a longer hearing, is that what that is?
That means the case is not over, and then we would turn to the objector, they would put on their case in chief, and then the candidate would respond, and everyone should be prepared to do that tonight, as we said. So is there, all right, any further discussion? If not, I'll call the roll. Chairman Saller,
Here,
Member Miller? Well, wait a minute, here, or are you voting for the motion, or yes or no?
am I voting for the motion
There's a
that was
motion,
seconded by
Yes.
Carrie?
yes.
I am against that motion, so I'm voting no because I believe in the law.
Okay. Member Miller,
Yes.
Member Goings?
Yes, the motion.
Okay, so the motion to dismiss is denied, which means the next thing that the board would do is entertain the case in chief. And because the burden is on the objector of establishing that there's an impediment with the election code, Mr. Wiltsey, you would go with your case first.
It was my belief that we were going to handle this and that council would ask for time to answer his, answer the objection. 'Cause I don't think we're really at issue, but the other thing I have right in front of me that I'm prepared to file tonight is a motion for subpoenas. Subpoenas for Cheryl
So we're
Smith.
here for a hearing, and quite frankly, this is just a delay tactic and a way to drag this out and waste everybody's time and money. We're here for a hearing.
I
Quite
honestly
frankly, we
didn't
can
see this
proceed
as
on
a
the
hearing
filings.
tonight because I thought we were gonna have the argument on the motion to strike.
We did. Now we're ready for a hearing.
All right. You want me to pull a chair up so that the witnesses can be?
I'd like to know who you're calling as a witness.
Call my client, I'm probably gonna call your client.
See the relevance.
This is now a hearing.
I understand what this is.
If you're gonna make an objection to relevance, that I'm gonna call your client as an adverse witness, my client, then please state that to the panel.
Of course, you can call her as an adverse witness. She is the adverse witness.
Okay, would you please just address your comments to the board and
Yes.
another? Now, court reporter, where would you like the witnesses?
Carrie,
Wait, me?
do you want to explain?
No.
Oh, okay, never mind. You know, take the 5 minutes.
Why?
I have no.
I should take a 5-minute recess.
Make a motion.
My daughter keeps texting. Can I make a motion, please?
Sure. Is there a second to motion for a 5-minute recess?
Sure.
All in favor, aye?
Aye.
5 minutes time.
Probably cups, like the water cooler.
Yeah.
Did the house get the, do you have the nomination petitions too?
Yes, they do.
Can I have the witness sworn, please?
You started hearing me better. Could you raise your right hand? Do you solemnly swear to speak the truth, the whole truth, and
Could you state your name for the record, spell it, please?
David Allgood,
Mr. Allgood, where do you reside?
I reside at 13152 Leonard Lane, Poplar Grove, Illinois.
Are you a registered voter in that location?
Yes, I am.
What is your interest in bringing this objection here, hearing right now?
To help eliminate confusion and promote transparency.
And in fact, were you previously a precinct committee person or committee person under the statute for the Republican Party here in Boone County?
Yes, I have served as a committee person.
And have you had experience with government here in Boone, in Poplar Grove, the village itself?
Yes, I have.
What would that be, sir?
I have served as a planning and zoning commissioner here prior to serving as a trustee. Now currently serve as the planning and zoning commissioner again.
Okay, thank you. Mr. Albert, I'm handing you what has been marked as exhibit number 1 for identification. Do you recognize that document?
Yes, I do.
What, if anything, does that purport to be?
I'm sorry.
What, if anything, does that purport to be? What is it?
This appears to be a statement of candidacy nomination by caucus that was filed during the collection process.
When did you first become aware that this statement was sworn that there was a caucus of the Republicans?
Shortly after the filings, when I received copies of all of the paperwork that was filed for request to be on this year, or this next term's ballot.
And how many years have you been in Poplar Grove as a registered voter?
Since 2018, so 6 years, but almost 7 years.
And have you ever heard of a Republican caucus being done in Poplar Grove?
No.
And what is your concern, if any, about this allegation of being a Republican candidate for village presidents duly nominated by said party's caucus?
Objection, his interest in the matter is relevant, but his concern is it's not relevant to this proceeding.
I think it's completely relevant.
So generally, these procedures are strictly following the code of civil procedure. I would recommend that objection be removed.
I make a motion to be sustained if there's a matter of time.
Is there a second to sustain the objection? Motion is for the second. Is there a motion to overrule the objection? All in favor, aye. And all opposed? Motion carries.
Thank you. Could I have the question read back to the witness, please?
What is your concern about this allegation of
My concern is that the voters would believe that the candidate is being supported by a group of individuals who chose her, and that doesn't appear to be the case.
Meaning the Republican caucus.
Correct.
And why do you think that's problematic?
I believe it's problematic because it misrepresents the plan.
And when you say filing, you mean the state candidacy,
Yes,
paper itself?
yes.
Do you go door to door from time to time politically in this community?
I do.
And have you been involved in municipal elections here in Poplar Grove?
Yes, I am.
Have you ever asked people if they were Republican or Democrat when you're at the door in connection with these campaigns in Poplar Grove?
I do not.
How many campaigns have you been involved in Poplar Grove? I mean, as a candidate. not
As a
just voter.
candidate,
Yeah.
this is my third election campaign.
Now, you and I have discussed preparing this case, various pages of the state election guide,
Correct.
and whether, if anything, did you notice with respect to this form, SVE P1K?
This form was listed in a section of the guide for townships, not for this particular municipality, which doesn't use this form. This is the third time I've participated in election campaigns, and I have never seen this form used there previously.
And what, if any, impact do you think that'll have on the voters?
I think it could be misleading.
Just, I'd like to leave a standing objection. I don't want the board to have to vote on every one. It's like, objectives, no line of questioning.
What's the basis of the objection?
Relevance, I don't think it matters what he thinks other voters may be an issue for voters.
Okay.
Thank you.
Mr. Rob, would you have exhibit 1 up there? Yeah.
Yes, I do.
In addition to the statement about being nominated at said party's caucus, does this indicate that the candidate is a qualified voter of the Republican Party? If we need to refer to it, please do so.
It does say, yes, it does say that she is a qualified primary voter of the Republican Party.
And that she is the office for the, she is a candidate for election to the office of village president, village Poplar Grove vote.
That is what the form says.
And what does it say at the top for party?
At the top, it says independent.
What does it say for district?
It says Poplar Grove.
And to your knowledge, is there any district called Poplar Grove?
Not to my knowledge.
And as a consequence, did you also look at the affidavit that's attached to the objection?
Which affidavit?
The affidavit that's attached to the objection. Now marked for the record as exhibit number 2. So I'm handing you what I marked as objectors exhibit number 2. You recognize that document?
Yes, I do.
And is your signature anywhere on that document?
Yes, it is.
In referring to the paragraphs 1 through 16, are there any indications that you make on there regarding misleading nature of this information that comes from this statement of candidacy?
Is there misleading, is there a statement of misleading information on the statement of candidacy? Yes.
Yes, what paragraphs is that, sir?
Well, there's misleading information, it addresses misleading information in paragraph 10, page 2, box entitled district. There's a question on office.
I'm going to object again, I'm sorry. He's reading from somebody else's affidavit.
Sorry, counsel is reading from this objection.
He's reading from the objection? Okay, that I withdraw.
Thank you. Looking at your 16 paragraphs, where, if any, does it talk about misleading, confusion, and so forth? Any other paragraph? Could you read paragraph 15 into the record, please?
Certainly. Paragraph 15. This is false, misleading, and likely to cause voter confusion in an election contest supposed to be nonpartisan.
And when you say this is false, what were you referring to?
Was referring to the statement of candidacy.
Exhibit 1, which we've already talked about. Exhibit 1, which we've already talked about.
That is correct.
You now look at the affidavit that is attached to the exhibit number 2 for identification. Is that affidavit, are you familiar with that gentleman?
Yes, I am familiar with this gentleman.
What kind of office do you hold that you know?
I believe that he is Secretary of the Boone County Central Committee, and he may also be a committee person.
And also, in that affidavit, are there statements of misleading or voter disinformation, voter confusion also made?
There are some statements in here that do lend itself to be some substantial voter confusion.
Could you just number those paragraphs for the record so we know where that is?
Paragraph 8. Paragraph 10.
Okay.
And paragraph 4.
Anything else?
Paragraph 6 specifically talks about the BCRCC. It's not slated a caucus, whereas the statement of candidacy that I am looking at here, Exhibit 1, says that there was a caucus and that the individual was selected at caucus.
Are there any other reasons that you have your own mind about voter disinformation or misinformation that you want to tell the tribunal today?
The structure of our environment has become incredibly sensitive over a handful of years. And when people cast a vote, they're doing so on what they believe is the best information given to them. in this day and age, information is much more readily available. Years ago, getting a copy of this information was time consuming and more rigorous. Now it's, you send one email, you get one email back. I'm really concerned about the overall health of the community with information. It is, so many items related to misinformation is starting to drive down lower voter turnout, starting to drive down confidence in the elected officials. It's really starting to me feel like it's causing the decay of the structure. And that to me is concerning.
I have no further questions. Tender to witness.
Counsel and board's attorney, thank you. Sir, did you sign my client's nominating papers?
I did not.
Did she ask you to sign her nominating papers? And
She
then
did
you
not.
refused? Okay. Are you an attorney?
I am not.
You've been involved in.
Objection, this is beyond the scope of the.
You know what? Strike that question. Sir, on direct examination, you discussed that you thought there was an issue, or one of your concerns was when you saw the statement of candidacy. It's noted the form SBE number P-1K. Is that correct?
That is correct.
And you either looked into it or knew from previous information that that was a state of Illinois candidate's guide form for townships as opposed to for villages.
That is correct.
Are you aware that the candidate's guide is not law, but simply a guide?
I am aware.
Thank you. Now, you testified a minute ago on direct examination a little bit about the statement of candidacy. Do you still have that in front of you?
I do.
Okay. So on the top of that, it says statement of candidacy, correct?
Correct.
Underneath there, it says name Suzanne Day Earp, correct?
Correct.
It lists an address in Poplar Grove, correct?
Correct.
The thing says office, and underneath office, it's written village president, correct?
Correct.
Okay. And then under district, it says Poplar Grove, correct?
Correct.
You stated on direct examination that there's no district you're aware of that is titled Poplar Grove, but that is the village we are in, correct?
That is correct.
And Poplar Grove has an election coming up for village president, correct?
That is correct.
And I guess lastly, in that top box caption where it lists party for the statement of candidacy, it lists independent.
That is correct.
I have no further questions.
Any redirect?
I have no redirect.
Sir. And you may call your next witness.
I call Cheryl Russell Smith to the stand. State your name and address for the record. I'm sorry. Swear the witness. And what do you, the residence address?
Because I object, I don't think witness needs to give her personal address to everybody watching this live stream.
Do you, are you a registered voter at that address? Did you pull the election statement? I direct your attention to exhibit number 1, which I believe is the statement.
Okay.
Let the record reflect that I hand to you document marked exhibit number 1. Do you recognize that document? You've seen it before? When was the last time you saw it? When was the first time you saw it? It's notarized in your office by your son, who's a notary public, is that correct? Did you fill out that form for the candidate? Did she fill out that form? I have no further questions of this witness.
Oh, I'm sorry. I'm sorry. That's okay. Ma'am, were you involved in, sorry if I have one moment with my client. Ma'am, you were assisting my client putting together her nomination packet when you printed out this form, correct?
Correct.
At that time, did you help her go over the rest of her nomination packet?
And I looked at the nomination papers and she had one already filled out. And it said it wasn't consistent with the other papers. So it was my fault that the statement of candidacy got pulled. Because I just went to the computer and I quickly did one and I didn't watch when she filled it out. I wrote notice Republican. But it was my fault that I pulled it out. And just because the other one had the wrong information, it wasn't consistent with the petition packet. So I knew it had to be consistent and I knew it was. I just saw statement of candidacy at the time. So it had nothing to do with substantial.
So when
Very
you,
first time.
so when you guys did this, like I said, so you had all of her signature pages at that time, correct? And it was after you looked at all of those signature pages, those were already completed and notarized?
Yes,
And it was after you looked at all those that this form was even printed out off the internet?
yes.
No further questions?
What do you think? Do you know who filled out that form after you printed it out?
Susanna,
I didn't. That's one of the things I'm trying to establish. No further questions.
witness?
I'd like to call the candidate, Ms. Suzanne Day. Would you say your name and spell it for the record, please?
Nan Elaine Day, Suzanne,
Oh.
Elaine Daybarp.
Okay. How long have you lived in Poplar Grove?
A total of 30-some years. We had a break in between. I raised my children here. I was schooled in our schools.
Okay.
Yes, I lived here. Now we've been back for almost 5 years.
Okay. So you, testimony that I heard before, I draw your attention to exhibit number 1, is the statement of candidacy. So you filled that out.
I did.
Did you read that before you signed it in front of the notary?
Actually, I was in kind of a hurry and I assumed it was the correct form. It was an honest mistake. I filled it out and moved on. It wasn't a lie or anything of the above. It was an honest mistake, which we all make.
Understand. Do you intend to hold yourself out as a Republican Party candidate for mayor of Poplar Grove?
No, I would be an independent. Although I do know that some of my competition is very active in the Republican.
So you said it was a mistake, you said you read it, but didn't realize that it said it nominated by the party's caucus?
Yes, I didn't realize it said caucus. I did have the correct one filled out. I had one mistake on it. We quickly printed another. Again, it was my first try at candidacy, and we had no guidance as far as the forms. Normally, the clerk gives the packets out, but this year, for some reason, that didn't happen, so we just did the best.
So Mrs. Smith pulled that form off the internet for you, is that correct?
She did.
And after you filled it out, her son notarized that, and so that it says that you had sworn in front of him that that was true and correct, is that right?
Apparently. Apparently.
That's what happened, right?
Apparently.
Well, I mean,
Apparently.
did you sign it in front of the notary?
Apparently. My name is here and my signature.
Oh, you don't, oh,
Apparently I did. My name is here. Apparently means apparently I did.
I'm not trying to argue.
Yeah.
I'm just trying to establish some of the elements of what happened. No further witness, no further questions.
Just to clarify, you filled this statement of candidacy, and bottom of it, you have your signature,
Yes.
and you are the one that signed that.
I-
And you then, well, not you then, you strike that. When you signed it, you did that in front of the notary and they notarized your signature.
Yes.
I have no questions, or no further questions.
But you never were at a Republican caucus.
Objection outside the scope.
No, this is. Let me rule on that. I'm following up on this.
How is there really too much to discuss?
She's talking about fixing her signature and reading it and so forth, and whether it was read,
I explained, sir, it was a mistake.
but you didn't read it.
I already
Objection,
had-
this is outside the scope, so please don't answer until it's.
I want to clarify that point, and I don't want to have to go back and read it. If you're going to overrule my objection,
She. Right, what she said.
and I believe she said no. I mean, I'm
No,
trying
she
to,
said apparently, then we cleared it up on cross,
okay,
now you're asking questions that are not related to my cross.
I have no further questions.
The next witness?
I have no further witnesses. If council wants to do his case in chief, and we can close.
I have no case with you.
Would you really like to make closing arguments?
I do. So now we know how to act. And as the chairman of the board said, there are 6 elements. And the 6th element is not properly fulfilled. It may have been an honest mistake, but it's a sworn under oath statement, and it's not accurate. So that's really this case in a nutshell. It purports to say that she was nominated by a party that didn't have a caucus, but she signed the paper. We now know that it was given to her by Ms. Smith, and that she filled it out. By her testimony, she didn't notice that. But that's not swearing a true statement on growth. And I think that's what element number 6 implies. The notarization has to be as to something that is true. That's all I have.
I mean, I guess without wasting everybody's time, I would ask members of this board to recollect all arguments made in the motion to dismiss as I stand. I think those are all applicable here. We've now heard live testimony, and I actually think we have some clarity that works in my client's favor. There was no testimony that there was ever a voter that saw this statement of candidacy with this one minor defect. The testimony that was unrebutted was that my client was at her friend's house. Her friend noticed a mistake on the statement of candidacy that she did have, and they printed out a new one, and that was after all of the signatures were already gathered. So that is even affirmative testimony that no voters saw this statement of candidacy, and therefore there cannot be any voter confusion. I understand what council is trying to argue is that this statement negates the entire statement of candidacy. And the law simply does not agree with that argument. The Illinois courts, again, go out of their way to say, first of all, ballot access is the default. We liberally construe statute to allow ballot access. What we want is for the voters to make the decision, not have that decision taken from them. And so unless there's no other choice, what we should do as a community is we should allow candidates to be on the ballot. As part of that, where the law has kind of trickled down, is that on signature pages, we are a lot stricter with the compliance because voters see those, they sign those, and if the preamble on a signature page says you're running for trustee and you're really running for president, that's a problem. But if there's a minor issue on the statement of candidacy, the line of cases in the state of Illinois says that as long as you substantially comply. And the couple I cited in the motion, one again where somebody left out a very important line about that they are and I will misquote it, but it's in the motion, a qualified primary elector or qualified primary voter of the Democratic Party. That is very relevant. Another one where somebody literally left out the office they were seeking. And what the Illinois courts have said is you take that statement of candidacy and you look at all the nominating papers together, and as long as it can be figured out what office the person wants to run for, then the statement of candidacy is substantially complied with. And that's what we have here. It is clear to me, just looking at the statement of candidacy, what office my client wanted to run for. But if we have to get past that, you take all the nominating papers together, and it is as clear as day what she wanted out of the statement of candidacy. She substantially complied with the law, and this board should deny the objector's petition in order that my client's name appear on the ballot in April of 2025.
Yes, I want to reply. The testimony is that there's going to be voter confusion. It's in the pleadings, it's in the statements by the objector. No evidence has come out that that's not the case. Period. Stands unrebutted. There's going to be voter confusion. That evidence stands unrebutted.
Okay, so the board has now heard the case and you need to make a decision. So the objector basically has an argument in the objector's petition that the nomination papers are deficient because of conflicting information in the statement of candidacy filed by the candidate. So first of all, the statement of candidacy says in it, the language that everyone has been talking about, that she's a qualified primary voter of the Republican Party. But it also says at the top of that sheet that she's running as a member of the Independent Party. Petition sheets on the top of each one states that the candidate is an independent candidate. So the objector claims that the form used by Suzanne Baker for her statement of candidacy by the candidate for the municipal office of village president is completely incorrect, and therefore it's false, misleading, and likely to cause voter confusion. Now, as far as use of the wrong form, the election code doesn't require any particular form to be filled out. What it requires is that candidates swear to a statement of candidacy, and that has 6 elements. 1, you need to make sure, does the statement of candidacy set out the address of the candidate, the office for which she's a candidate, state that she's qualified for the office, states that she has filed a real file before the close of the filing period, a statement of economic interest, shall request that her name be placed on the ballot, and that has to be sworn or subscribed to before an officer authorized to take notes. So those are what the requirements are about what the statement of candidacy has to say. Now, with respect to the issue of voter confusion, generally, when people are trying to prove voter confusion, they actually bring in voters who attest that they're confused by it. Now, the candidate is saying the voters are not going to be confused here because they were never even given or shown statement of candidacy.
How do we know that?
How do we know that they weren't shown statement of candidacy? There was no evidence that, there's nothing before the board that shows that any voter other than the objector with the statement of candidacy.
Okay, because like I said, when I did my signatures, my statement split my signature. Very first occasion.
Did you, so you showed that to
Yeah,
everybody?
absolutely. I explained to them, this is where I'm running for, here's my statement, this is where I live. And then I went on it to them before I asked the voters in. And I also want to make sure that they register voters. So what I gathered is that she admitted that she made a mistake. I get it, we're all human. She admitted that she was in a hurry. She admitted, she said she was caucus. She admitted saying that she was proud as a Republican. She admitted signing in front of a notary. She admitted second attempt at a statement, so it took 2 times to fill it out. So me, if I was watching this and I knew this was going on and I signed her petition, I probably would vote for it because to me it's voter confusion because it wasn't truthfully filled out. She also admitted, and the attorney admitted, that she printed it for her. She read through it, she printed it again, she read through it, and then her son notarized it. So to me, that's voter confusion. To me, if I signed her petition, I wouldn't vote for it. First, she didn't present her statement with her signatures, which I think everyone should. They don't have to, there's no law. But I'm just saying, for me, if I'm looking at it, I would have been angry, knowing that this wasn't presented to me, which it should be. This is my opinion. I'm one. So,
So what you have to do is you have to look at the evidence that's been presented before you, right? So there has not been a testimony by a voter that is confused. But what the courts said is that you need to pay attention to the petition, because the petition sheets are what go before the voters. So if there's problems on the petition sheets, that's fatal. But they have kind of said, with statement of candidacy, unless there's evidence that that was shown to the voters before, that you need to better articulate what the basis for the confusion will be. So what the board has to decide is, what does the law require these petitions to say? And did the candidate complete what the law said that they were required to do?
so no form is the proper form that we used all these years is irrelevant in this case.
If I recall,
I'm asking the attorney.
Well, the State Board of Elections has suggested forms that include the ingredients required by the law. But sometimes candidates create their own forms, use a different form. There's no requirement in the election law that they use specific forms. So it's not wrong that people use it, it's just not required that they use it.
I don't know, I have a different opinion.
You think the law requires them to use a specific form?
No, I just have a different on the whole. Well, there should be one form for our village, and caucus form should be allowed. So that way there is no chance for confusion. Because if she uses the proper form or the form that you've always used, like I used in the last 3 night elections, there's no confusion. And I present my statement to the people I'm asking to sign. I also make sure that I ask for the registered voter. And I apologize to them if they don't know. I said, I'm sorry, I can't say this. Which has nothing to do with it, so I'm just saying how I am. So I would like to talk to you, our attorney, for a minute alone. I have a couple questions that I don't want to ask here. Is that possible? Is that, and I don't mind.
Well, I can meet with the board members individually to answer legal questions.
Okay, and I'd like to ask you a legal question.
I have no objection to the recess if there's anybody cares. I'm sure you probably don't, but there's no objection over here.
Yeah, I mean, I can also answer your question. Um,
I have a private question. Do I need to ask for 3 minute recess?
Okay, is there a motion for a 3-minute recess?
That's fine.
Is there a second? All in favor, aye? Opposed? Either
Motion to deny the petition. As stated under section 10.5 of the election code that provides that the required statement of candidacy be substantially compliant. It provides all the information necessary under the written law.
So, so the motion is to deny the objector's petition. I don't think we grant the statement of candidacy because that's not something we need to act on. But is there a second then on that motion to deny the objector's petition? Is there a second? Okay, that motion fails for lack of a second. Is there a different motion?
Yes, can you have it in my motion, please?
So you would make a, so the motion to deny the objector's petition failed, so I make a motion to grant the objector's petition. Is there a second to that motion?
I'll second
Discussion?
Yeah,
Go ahead.
last time we went through this 2 years ago, I did a lot of research into this. There's a 250-page manual that I read, and basically stated that electoral boards very often ignore the law, and they very often vote with emotion and bias, and everybody's known they have bias, and that is why the circuit court is there. The circuit court is there to uphold the law, and the purpose of an electoral board is to make a quick, reasonable decision to try to uphold the law, and if they don't, that's what the circuit court is there for. And the law is very clear here, and we went through this, and the law was quoted. It's probably be quoted again, so that's all I need to say. Some people don't want to follow electoral code law, so it's not very complicated.
Any further discussion?
Here, could you help me out a little term what we just discussed?
Carrie Lynn or Carrie Lynn?
I'm sorry, Carrie.
I was confused.
Give an explanation of why.
What you discussed with me out there is that you had concerns that the statement of candidacy, if it was false apart, would that make it one of the mandatory documents wasn't adhered with, so that they weren't in substantial compliance with the provisions of the election code. That's what your concern was. Any further discussion? All right. If not, then there's a motion to grant the objector's petition. And there's a second. Roll call vote on this. Chairman Sattler?
I do not agree with violating electoral code law. I vote against.
Okay. Member Miller?
Agreed. Yes.
Member Goins?
Yes.
Okay, so the motion carries 2-1. The board is required to issue a written opinion in open session. And in anticipation of what could possibly happen tonight, I prepared 2 different written decisions. So I'll read the one that granted and sustained it. The duly constituted Village of Poplar Municipal Officers Electoral Board. And I'm going to talk fast on this, Chair. For the passing upon the objection of David Allgood, objector to the nomination papers of candidate Susan Day Earp, candidate for the office of village president, consisting of Chairman Don Sattler, village president, member Carrie Miller, village clerk, and member Jeffrey Goings, village trustee, was organized by law in response to a call issued by the chairman of the electoral board for the purpose of hearing and passing upon objections to the nomination papers of candidates. Finding. The board has heard and determined objections to nomination papers and finds as follows. 1, candidate filed her nomination papers with the village clerk or designee. 2, the objector filed an objector's petition to the nomination papers of the candidate with the village clerk or designee on November 25, 2024. 3, a call to hearing on the objector's petition was duly issued and was served on the members of the electoral board, the objector and the candidate by mail and/or by personal services required by law or otherwise legally waived. 4, a public hearing was noticed and held on the objector's petition on December 4th, 2024 and December 18th, 2024. 5, the following persons, among others, were present at the hearing. A, Donald Sattler, chairman. B, Carrie Miller, member. C, Jeffrey Goings, member. D, objector David Aldred, impersonated by counsel David Wiltsey. E, candidate Susan Day Earp, impersonated by counsel Robert L. Winden. 5, the electoral board was legally constituted according to the laws of Illinois. I'm sorry, that was 6. 7, at the first electoral board hearing on December 4th, 2024, the electoral board, before holding its hearings on this matter, first adopted rules of procedure. 8, the board considered and denied the objector's verified motion for substitution of board member for cause based on the fact that the electoral board members do not have a legal authority to disqualify statutory members and for other reasons stated in the record. 9, the board considered and dismissed the objector's petition. For the reasons stated in the record. 10, the board considered evidence and arguments submitted by the parties as detailed in the transcripts of the hearing, which is incorporated into this decision as if fully set forth herein. 11, the board discussed and deliberated on the objector's petition in which the objector claims that the candidate's nominating papers were not compliant with the Illinois Election Code. Specifically, the objector claimed that the candidate used the improper form for statement of candidacy, resulting in voter confusion. 12, the election code requires that nomination papers must include statement of candidacy, setting forth the address of such candidate, the office for which she is a candidate, and shall state that the candidate is qualified for the office specified and has filed or will file before the close of the petition filing period. A statement of economic interest is required by the Illinois Governmental Ethics Act, shall request the candidate's name be placed on the official ballot, and shall be subscribed and sworn to by such candidate before some officer authorized to take acknowledgements of deeds in the state, 10 ILCS 5/10-5. 8, the apparent purpose of the statement of candidacy is to obtain a sworn statement from the candidate establishing his qualifications to enter in the primary election for the office he seeks. That's from Lewis versus Dunn, 63 Illinois 2nd, 48 and 53 from 1976. B, the Village of Poplar Grove has a partisan system of elections. C, for independent candidates running for office in a partisan system elections, the required statement of candidacy must be submitted in substantially the form provided by section 10-5 of the election code. In order for a statement of candidacy to be found to substantially comply with the election code, the form used must evidently be one that contains the essence of the form in the statute. 1, giving the correct idea, but not necessarily the exact expressions in the statutory form. People X. Rel. Davis versus Chicago, Burlington and Quincy Railroad, 48 Illinois 2nd, 176, 183, 1971. D, Illinois courts have observed that a substantial compliance with the statutory requirement requires a fair portrayal of the statute's chief features in plain language. Chicago Bar Association versus White, 386, Illap 3rd, 955, 962, 1st District, 2008. E, the doctrine of substantial compliance is not operative to release a candidate from compliance with the provisions intended by the legislature to guarantee a fair and honest election. Aiken versus Smith, 2013, Illap 1st, 103, 441, paragraph 12, citing Madden versus Schumann, 105, Illap 3rd, 900, 903 to 04, 1st District, 1982. F, while it is not beyond dispute that access to a place on the ballot is a substantial right not to be readily denied, we must also keep in mind, however, that the regulation of elections is within the power of the legislature, within the constitutional limitations. For as United States Supreme Court has recognized, it is beyond question that states may and invariably must enact reasonable regulations of parties, elections, and ballots to reduce election and campaign-related disorder. Jackson Hicks versus East St. Louis Board of Election Commissioners, 2015 IL 118, 929, paragraph 32. G, in this case, the evidence shows the candidate's statement of candidacy did not substantially comply with the requirements of the election code when presented for filing because the candidate swears in the form that she was selected as a Republican caucus, but her petition sheets indicate that she's running as an independent candidate. H,
Furthermore, the evidence demonstrates that the inconsistencies between the candidate's statement of candidacies and nominating petition sheets is likely to result in voter confusion as to the office used for. For these reasons, the objector's petition is sustained and the candidate's name shall not be certified to the ballot. Order. It is therefore ordered, adjudged, and decreed that the objections of David Allgood to the nomination paper of Suzanne J. Earp are sustained by a vote of 2-1 of the Electoral Board as to the objector's petition. The board orders that the name of Suzanne J. Earp be stricken from the record for the office of village president for the April 1st, 2025 consolidated election in the village of Poplar Grove. It is further ordered that the Electoral Board's attorney is directed to personally serve a copy of the decision on the parties in open proceeding or to mail a copy of the decision in the United States mail in a sealed envelope or package with postage prepaid, addressed to each party affected by the decision or to such party's attorney of record, if any, at the address on record for such person in the files of the Electoral Board. The decision may be executed in counterparts by all of the members of this board assembled to be together in a single instrument. Decided at the Village of Poplar Grove, Illinois, December 18, 2024. So then, is there a motion to adopt this written decision?
Excuse me.
Is there a second?
Second.
Any discussion? If not, then I will take the roll. Chair Sattler?
No.
Member Miller?
Yes.
Member Goings?
Yes.
All right, the decision passed. So then I will ask the board members to sign copies of this decision. And then we will send it on to the objector and the candidate. I get language that said the board considered and granted/denied. And so I had crossed out granted because I wasn't sure what they were going to do with that. But then I carried on there based on the fact the electoral board members do not have the legal authority to disqualify statutory members, which was a carryover from the other motion. So I've stricken that also. So there is some language stricken out on page 9.
Each.
Oh, here. Sorry.
I want a thorough rule.
So then, if we can have the attorneys come forward and get copies of this decision. Signed by everybody.
Is it possible to get a second copy of these? Copy? Thank you. Yeah, I just want to take one. So, for the record, or more.
Yeah, I have a bunch of them, but I
Okay.
just need one.
Yeah. And I think for the record, I'm accepting receipt of the written decision in open session. Thank you very much. Yeah.
When we finish this one.
Yes.
Okay. All right. So then the next matter on the agenda is 24 EBOC David Aldridge versus Bruce Moore.
Just to be clear, there's nothing more on hand happening tonight on this matter.
That's correct.
Okay, I will see everybody in the future. Thank you for your time. Yeah, Council.
All right, so at the last electoral board meeting, indicated he was withdrawing his candidacy. Newly constituted Village of Poplar Grove Chairman Don Sattler, member Kerry Miller, and member Jeffrey Goings was organized in accordance with the Illinois Election Code for the purpose of hearing and passing on objections to nomination papers of the candidate for village trustee Bruce Moore. The board, having heard the objections to the nomination papers, finds the candidate having since is hereby ordered that the objection of David Allgood objected to the nomination papers of candidate Bruce Moore is hereby dismissed. Now, did we actually receive the withdrawal of candidacy?
Yes, President Ray.
I just have the withdrawal form, and I forgot my notice.
Is there, were you in the notary period?
Because I expired, so I had to retake it with my new name.
Okay. I'm a notary, so
I don't have my seal with me, but I'm a notary and I can notarize it and seal it later because I would rather not dismiss it till we actually have received the
Okay,
actual
well,
withdrawal.
he just signed it, you want to sign it?
Will you attest his signature?
Because I'm number two, I think, for Steve.
Okay, so this is a withdrawal of candidacy. All right, can you suppose stress at the top? Is this your signature here?
It is.
Okay. So I'm putting on this form, DuPage County, because I'm a notary. So when you see it and it says DuPage, that's why it says that. That's where my notary job is. Or, okay, so here. Okay, so is there a motion then to adopt this decision?
So moved.
Is there a second?
Second.
And now I will call the roll. Chair Sattler,
Yes.
Member Miller, Member Going.
Yes.
Okay, so that motion carries to adopt that decision. Can anybody please sign that? Let's go. Okay, and then while we're signing that, the other thing that we have to do, is we have to have public comment for the electoral. Is there any public comment that people would like to make related to the electoral board? Okay. And as soon as this is signed, we will tender it to the parties. And then the electoral board can adjourn. All right. Can I give you a copy of this? And, Mr. Wiltsey? And then we'll let the record reflect, tender a copy of a signed decision in open session to the candidate and to the objector. Is there a motion to adjourn the,
So moved.
I'll second.
all in favor, aye?
Aye.
Opposed? All right.